Stop scrolling. If you have a green card application pending, a visa interview coming up, or travel plans to or from the United States, what happened this week in immigration could directly affect you. And I mean directly. Not in a vague, general way. I am talking about policy shifts, processing changes, and travel restrictions that are already in effect right now. Stay with me through this entire video, because by the end, you will know exactly where things stand, what you need to do immediately, and what mistakes to absolutely avoid right now. Immigration news in the United States moves fast. 1 week of silence, and then suddenly a flurry of executive actions, USCIS announcements, State Department updates, and court decisions that completely reshape what millions of people can expect from their immigration journey. This week was one of those weeks. Whether you are waiting on an employment-based green card, going through the family preference system, holding a non-immigrant visa, or simply trying to understand if your travel back into the U.S. is safe, this week brought developments that you cannot afford to miss. Here at U.S. Visa Updates, we track every single one of these changes, so you do not have to piece it together from a dozen different sources. So, let us get into it. And pay close attention because I am saving the most critical update for later in this video. It is the one that almost nobody is talking about, and it could affect far more people than the headline stories. Let us start with green cards because the movement this week was significant. The visa bulletin for the coming month has been released, and the dates have shifted in ways that will surprise people in both directions. Some categories moved forward, giving hope to applicants who have been waiting years. Others retrogressed, meaning that people who thought they were weeks away from filing suddenly find themselves pushed back. This is not unusual in the history of the Visa Bulletin, but what makes this month different is the scale of the movement in the EB3 category for certain countries. If you are a national of India or China in an employment-based category, you need to look at these dates very carefully before making any assumptions about your timeline. If you have an attorney, call them today. If you do not, this is the week to consult one, because acting on outdated information here can cost you months or even years of progress. And speaking of employment-based categories, there is something else happening behind the scenes that the Visa Bulletin alone does not tell you. Stay with me. USCIS processing times have been a constant frustration for applicants across almost every category. But this week, USCIS published updated processing time data on its website, and the numbers are telling a complicated story. Some field offices have seen dramatic improvements. Certain I-485 adjustment of status cases are now being processed faster than at any point in the last 3 years. On the other hand, some service centers are showing increased backlogs for I-130 family petitions and I-140 immigrant worker petitions. What this means practically is that where your case is being processed matters enormously right now. If you recently received a transfer notice moving your case from one service center to another, do not panic, but do track it closely. These interoffice transfers have occasionally caused administrative gaps that delay cases even further. Document everything. Keep every receipt notice. And if your case has been pending well beyond the published processing time, you may now have grounds to submit a formal inquiry or even consider a mandamus lawsuit. That last option is more common than people think, and courts have been ruling in favor of applicants in these cases with increasing frequency. Now, let us talk about visas. Specifically, what is happening with non-immigrant visa appointments at U.S. consulates around the world, because this week brought news that will directly affect hundreds of thousands of people waiting in line. Several U.S. consulates in South Asia and Latin America announced adjustments to their interview waiver programs. The interview waiver program allows certain applicants renewing their B1 or B2 visas to skip the in-person interview entirely, a process that has been a lifeline for people in countries where wait times for appointments stretch into years. The recent changes tighten some of the eligibility criteria, which means applicants who assumed they qualified may now be required to appear in person. If you or someone you know was planning to use the interview waiver for a visa renewal in the coming months, double-check eligibility right now. Do not rely on guidance that is even a few weeks old. The rules changed this week. But here is the thing, and this is where it gets really interesting. The interview waiver update is actually connected to a much larger policy conversation happening inside the State Department right now. I will explain that in just a moment. Let us talk about travel, because this is where the week got genuinely alarming for a lot of people. There have been new reports of lawful permanent residents, meaning green card holders, experiencing heightened scrutiny at U.S. ports of entry. This is not a new phenomenon, but the frequency and the nature of the encounters being reported has escalated noticeably in recent weeks. People with valid green cards, no criminal history, and clean travel records are being pulled for secondary inspection at rates that immigration attorneys are describing as unusual. Some are being asked detailed questions about their ties to their home countries, their employment history, and their recent travel patterns. A handful of cases have involved temporary detentions and coercive interviews. Now, this does not mean green card holders should panic and avoid international travel, but it does mean that if you are a lawful permanent resident and you are planning to travel abroad, you need to prepare differently than you did even 6 months ago. Carry documentation of your employment, your U.S. ties, your tax filings, and your family roots here. Know your rights. Know what you are and are not required to answer at the port of entry. And if you have a naturalization application pending, think carefully and consult an attorney before booking any international trip right now. Now, I promised you the update that almost nobody is covering, and here it is. This week, a significant federal court ruling came down regarding the use of social media screening in the visa application and green card adjudication process. For years, USCIS and the State Department have been expanding their use of social media data in making decisions about applicants. What the court addressed this week goes to the heart of how that data can be used, what disclosure applicants are entitled to, and whether certain denials based on social media content were lawful. The ruling does not reverse existing policy overnight, but it creates a legal framework that immigration advocates are calling a turning point. What does this mean for you? If you were ever denied a visa or had a green card application denied, and you suspect that social media activity played a role, this ruling may open a door that was previously closed. This is the kind of development that takes months to fully ripple through the system, but the attorneys who are paying attention right now are already advising clients on how to use it. Here at US Visa Updates, we will continue to track this case closely as it develops. Let us also quickly address DACA because this week brought yet another chapter in the ongoing legal saga surrounding the program. A federal appeals court issued a ruling that keeps the program in a state of legal limbo, which is unfortunately the situation that hundreds of thousands of dreamers have been living with for years. Current DACA holders can still renew their status for now, but new initial applications remain blocked. If you are a current DACA recipient, the most important thing you can do right now is check your expiration date and file your renewal as early as possible, ideally 6 months before your current work authorization expires. Do not wait. The legal landscape around DACA can shift with very little warning, and being caught with an expired status while a new case works its way through the courts is a risk you should not take. Here is the honest truth about immigration in the United States right now. It has never been more important to stay informed, and it has never been more difficult to separate accurate information from noise. The policies are changing faster than at almost any point in recent memory. The courts are active, the agencies are shifting their enforcement postures, and the consequences of acting on outdated or incorrect information are severe. We are talking about people's lives, their families, their futures. That is why the work done here at US Visa Updates matters. not to create fear, but to give you the clarity and the context you need to make smart decisions at every stage of your immigration journey. Every single week, something new happens, and every single week we break it down for you so you can stay one step ahead. If this video helped you understand where things stand right now, do one simple thing: hit the like button. It costs you nothing, but it helps this channel reach the people who need this information most. If you know someone going through a green card process, waiting on a visa interview, or planning to travel to the US in the coming months, share this video with them right now. It could make a real difference in the choices they make. Subscribe to US Visa Updates if you have not already, and turn on the notification bell so you never miss a weekly breakdown. And leave a comment below. I want to know which of these updates affects you the most. Are you waiting on a green card, dealing with consulate delays, concerned about travel? Tell me, and I will make sure we address your situation in an upcoming video. I will see you in the next one.